Hey everybody, it's Tracy, and after a few years of having a regulatory sandbox approach to digital asset licensing, the BVI has finally come out and fully enacted their virtual asset service provider license. And unlike what you see through the majority of the world, especially in the Caribbean, is that instead of giving potential entities that would fall under the licensing regime a very limited amount of time to comply, which is usually impossible, they're allowing those companies to simply apply for a license before the end of July, right? So assuming you get the licensing, not that it has to be approved, before the end of July, you can continue to operate. If not, they'll strike off the company and conceivably you'd be operating in violation of the law. But as far as the license goes, it's pretty rank and file. Like there's nothing wildly unique about it. The same application, paperwork, business plan, policies, procedures, extensive KYC, all of that is the norm, right? The application fee, $10,000, and it covers, your basic license activities, crypto exchange, hosting, custody, you name it. The big emphasis, which I find to be different when I read the act vis-a-vis other countries, especially in the Caribbean, is that it doesn't cover derivatives or any form of like security token, right? So you see this like in like a Singapore a lot of times where it's not like this one size fits all license. And if you want to dabble in both like spot trading of, let's say, Bitcoins, and then offer like derivatives thereupon, then you need a separate license, a securities license that falls under SEBA, and you wind up having to need two licenses, right? Whereas some of your, I would say, lower cost jurisdictions like Mauritius or Seychelles, they don't really differentiate, right? Like they don't, you could write options or what have you on any crypto, but it doesn't require an additional license to deal in those financial products. So it's sort of following in a tacit way, because obviously we have no laws or clarity. How the US views it, at least through the courts, is that certain crypto, like Bitcoin and the like, are not securities, but if you want to get into derivatives thereof, then you fall under like the Commodities Act. Well, in the Caribbean, they never differentiate between securities and commodities, and it all falls under the umbrella of what is a security, even though we know it to be different. So that's like a big emphasis. So like what I've gleaned from the process is that number one, it's going to take like 6 months, right? And they guarantee in the act that it's going to take 6 months, but they give early indications, the FSC does early on, as to whether or not the license is going to be successful. So you can kind of like ascertain whether you just are wasting your time or not, right? The second thing is, I think you have to be very constructive and very careful as to what you, at least what you signal to the regulator in terms of what, especially like in the exchange context, what you are going to actually offer, right? And like if you wade into the waters of like security tokens or crypto derivatives, then I think the obvious response is going to be, well, you need this license as well, which is a much harder license in my experience to get than what the VASP license would be here. So, it's interesting. And I think, just as a general rule, is it better than anywhere else? I think Bermuda is still a much better license, all told. Yes, like BVI, you look at like the fund activity, same with Caymans, it's obviously much easier than the Cayman Islands. And you have, 90% of the world's fund managers there, but 90% of the world's fund managers are domiciled in the BVI because it's like a 2-page form and it's a joke, right? So, that's the advantage of it, and that's not really the advantage of it here. So the question becomes, is it really relevant and important vis-a-vis like a license anywhere else? And I look at like the Bahamas, which obviously since the FTX debacle, where they had sort of this one size fits all approach and it fell under their securities laws for virtual assets. Now that doesn't exist, right? And granted, you really can't get a license in the Bahamas right now. But the question becomes whether it's really worth it vis-a-vis like the Bermuda, which I think is, again, I think it's a much quicker process, similar costs, and really a better written law that delineates how to get the license and how the license operates. So all told, I think, we finally have clarity, at least. And like, I know there's a ton of crypto, projects that have, domiciled in the BVI, which is fine, because just from a corporate standpoint, it's great for asset protection. It's not that difficult to get a bank account, so on and so forth. But if you're engaged in any sort of covered activity, now they're going to push you to get the license. And the way they really find that out, which is sort of silly, is like they look at the name, right? They look at the name of your company. If it says anything, blockchain, crypto, whatever, they're probably going to write you a letter and ask you to explain what you're doing and why you don't need a license, or why you do, whatever the case may be. And so that's really kind of what it is. ICOs are still safe. Like, there's no real, restrictions or guidance in terms of like launching an ICO from BVI, as there are in some places. Like I was investigating Barbados, which I'll do in a subsequent video, but requires licensing for ICOs. But BVI hasn't gone that far, with the caveat being, conceivably, depending on what you're offering, you may have to get a license with SEBA. But it's another story for another time. So that is the BVI VASP license at a glance. Have any questions, definitely hit me up. Happy to answer them as usual, and I'll talk to you next time. Cheers.